Right. So, how is everyone? Ready to talk contracts? Everyone says with such excitement. All right. So, today the schedule has us talking about the listing contract. So, we're going to go through that, which of course always brings up some fun discussions regarding agency, etc. So, I'll go through that. Before I get started, do you guys have any specific questions that you have for me? Exclusive right to sell. Let me make sure I get it. Listing agreement form 220. Any specific questions that you want to go through? Any burning questions that you have? All right. I guess that means we're good to go. So I am going to jump onto the listing agreement now. Share screen. I am at the SC Realtors forms. Get the format here so I make sure I don't miss any chat questions, etc. All right, so we're going to go through the listing agreement. Like I said, we'll use it as an outline, which of course always brings up good conversations that we can always get into here. A lot of times it also brings up questions that or topics that we can go through for the broker minutes. So give me a thumbs up if everyone can read the listing agreement that's on the screen. If you do not have or you cannot read it and you would like a copy of it, I always just go to the website I went to is the screaltors.org/forums. You can see in the top here, it asks you to enter your last name and your NRDS number, which you can look at by doing so. And then you have a breakdown of all the most recent forms here. You can also get it in DocuSign. This is just creature habit where I go. So I'm going to jump into that. We're going to go into this one. We've had a lot of things come up in the last couple of days as it relates to agency and listings. So this is actually going to be good timing. All right, so we're going to jump into it. First of all, the first part of all the contracts are the same. All contracts, I should say, are all fill in the blank. If you have anything that you feel should be added to it, that's going to be dipping into practicing law a little bit, and you just want to be careful on that. So the first part of this is obviously who are the parties to the contract. You've got the property owner as well as the real estate company, hereinafter called broker. So that would be where you would just put Keller Williams Realty Charleston Mount Pleasant, Keller Williams Realty West Ashley, Keller Williams Realty Islands, or Isle of Palms, or Keller Williams Key. Either one of those. If you do have Keller Williams Realty in there, it's not the end of the world. However, it just needs to be specified. It would be better if it were. This is where you also will put the time frame as it relates to the listing time frame. Now, this will be our first opportunity to break from the script to talk about the timing of it. Actually, no, it's dealt with later. We'll come back to that. So time period beginning on blank, ending on blank. I will tell you that this right now, in my opinion, the date here should be the date that they're signing the listing. It starts today, right? And it goes through X date, all right? So today's February 9th. Even if it's not going to go quote unquote on the market or in the MLS until next week or anything like that, this date here should be, in my opinion, to protect yourself, to have a contract dated today. We'll talk about the intricacies of the coming soon, what can be done, what can't be done, etc. As a matter of practice, I highly recommend you pick 2 days of the year that you have for your listings to expire. Not as big of an issue in this current market, but just as a matter of practice. I personally feel if you have all of your listings end at the end of June or the end of December, then you do not have to worry about the managing confusion of each month, what listings are expiring, what listings are not expiring. You just know that the end of June, end of December, you have listings expiring. So you need to make sure that you go in and re-up them or communicate with your client as to whether or not they're going to continue the relationship. Otherwise, you just run the risk of not paying attention. Next thing you know, the first of the month comes along, you've got an expired listing. They didn't realize it expired then. They're getting a bunch of phone calls. Next part would be the property description, your lot, block, section, subdivision. All that will come from the tax records. In a perfect world, you have a copy of the deed. However, if you do not, you do want to have at a minimum the address and the tax map number that you can get from the property records, and you can also confirm that by calling the county. Making sure you have all the information in there. In the event you are taking multiple listings, you have an investor that owns 2 properties side by side, you can do one of 2 things. The clearest, cleanest, best one is to have 2 separate listing agreements. In the event you are marketing them together, you can put them both on there. However, you do want to make sure that the sellers are consulting with an attorney to make sure that there are no issues with them being sold together. Then obviously the rest of the property description would go in here. Real estate described herein includes all improvement fixtures, appurtenances, and additional property, if any, described here. Typically, it's not here's what we want to include. Typically, it's what do we not want to include, right? So as part of your, and by the way, I'm just going to break away from this. This is in a listing presentation class. However, it is a good time to talk about different areas to talk about what to do, how to deal with this in your listing consultation. As it relates to personal property, if there is anything in the property that they are going to be removing and do not want to stay, it is my opinion and should be yours. They don't have to mandate it, but you can strongly recommend that they have those fixtures, appliances, whatever it may be, changed out prior to going on the market, preferably prior to having photography done. So if they've got their prize-winning chandelier that their grandmother gave them in the dining room and they're going to replace the old builder grade one in there, go ahead and put that in there. Well, I don't want to. It shows the house better with it in there. Okay, that's fine. Then you need to go above and beyond to make sure that everyone knows that that is not included in the MLS agent notes. You want to maybe put it in the public notes as well. And also you want to make sure in the contract where you typically would not put a chandelier as personal property, in the contract, you would put in there chandelier and dining room to be whatever the one is you're going to replace it. Okay, so that's just one area to jump off. Make sure you cover that here. Again, in this part of the listing agreement, it's very rare that you actually have someone, here's what I want to include. The discussion's normally, here's what I don't want to include. All right, so paragraph 1, the consent to disclose dual agency, designated agency. Couple things that come up here. I'm getting a lot of questions, which I love, by the way. Do not stop the questions. And if you think I'm talking about you, I probably am, as well as about 10 other people. So I don't want anybody to think if I bring up a question, you happen to ask me that I'm singling anybody out. Because I'll be honest, in the last 6 months, there has not been any questions that I've only been asked once. So I say that because I don't want anybody to ever hesitate coming to me, or anybody really, but particularly me, with questions. Please come to me with questions. Now, that being said, those questions also tell a story. I get a lot of questions regarding what type of agency should I have them do as it relates. We're seeing a lot of off-market properties now for sale by owners, those sorts of things. Understand that this first part of this paragraph right here says the seller acknowledges receiving an explanation of the types of agency relationships that are offered by the brokerage and the South Carolina disclosure of real estate brokerage relationships at the first practical opportunity at which substantive, I don't like that word, substantive content occurred between the agent and the seller. Very vague. I'm not super concerned as to when in this is what substantive contact is or anything like that. But what it does concern me is when people say, well, what agency should we do with this? That is up to the consumer. Right. So what this is stating is when they initial this, you've explained the two types of agency that there is in South Carolina, which is basically exclusive. Well, there's multiple, but the two that we're talking about is going to be either exclusive agency, right, which would then translate into either designated or dual if that opportunity presented itself, or a transaction broker, which is what that would be is if it were for sale by owner or an off-market property that did not want to be treated as a client. I want to reiterate, whether or not they choose to be represented, agency has absolutely nothing, representation and agency has absolutely nothing to do with compensation. Okay, so we're not talking about compensation here. So if you've got, an off-market property that does want to sell the property to a buyer you have, or you've placed them with a buyer, they'll pay you, but they don't want to be represented, that's fine. They would be a transaction broker. And then they would pay you through the transaction brokerage agreement. So just keep in mind that when you have them initial this, you're having them initial that you have received an explanation, right? Not just seeing the disclosure, right? So beyond that, owner acknowledges that after entering this written agreement, broker might request a modification in order to act as a dual agent or designated agent in specific transactions. And then they have the choice of whether or not they will or will not accept dual or will or not accept designated. So as a quick reminder in this situation of what that would look like, dual agency for you as a Keller Williams agent would occur on a couple of occasions. One, if by chance you were to bring a buyer to a listing that I had, or if I were to bring a buyer to a listing that you have. That's one of the rare occasions because I don't work with buyers. The second one would be if you are a husband-wife team. If you're a husband-wife team, you do need, that is going to be dual agency. So for instance, when Len and I, if we had, she represented the buyer, I represented the seller. Even if we were not, even when I was not the broker, that was considered, we consider that dual agency. That is a company policy, because you cannot just simply say it's going to be disclosed designated, meaning there still be an arm's length. It's just not proper disclosure to the consumer. The other time would be is if you are going to represent a buyer on one of your team's listings. Okay, so if you are part of a team, so I shouldn't say really husband-wife team, I should say any teams. Or if you do have which is the most common example of dual agency is where you do have customers that have chosen to be represented as a client, or consumers who have chosen to be represented as a client on both the buyer and seller side of a transaction. Now, a lot of times people default to dual agency in situations where they get a sign call, or they get someone that comes into their open house, or somewhere along those lines. That does not mean that you have to go into dual agency. Again, it's up to the consumer as to whether or not they want to, but they just have to understand is that they do choose to be a customer, that you're basically helping them fill in the blanks. So just something to keep that in mind. We're probably going to do, this is the second Wednesday. So next week will be the purchase, or Tuesday. Next week will be the actual purchase and sale agreement. And then the fourth Tuesday of the month is when we do a kind of an open topic. The fourth one's probably going to be a pretty in-depth one on agency specific situations and how to handle them. So just keep that in mind. All right. So before I go into terms, any questions so far? How's everybody doing? I started screen sharing a little soon. I want to make sure we are talking about contracts. So I want to make sure I keep everybody focused here. All right. Having heard nothing, I will continue on. But if you think of anything, type it in the chat box or speak up. All right, so let's jump on to terms of the contract. This is where you talk about the price of the property as well as the total commission. For those of you who have not looked at listing agreements too much in the last year, this is one of the changes that was made, is they took out how the commission is divided. Commission is divided, that's shown in a later paragraph. Commission. So here you're basically talking about the purchase price of the property or the sales price of the property, and then the total fee of X amount, either in dollars or commission. If broker, owner, another broker, any other person or company produces a buyer who is ready, willing, and able to purchase this property on the terms described above, or any terms acceptable to the owner, they owe that money. Owner or broker agree that there should be no variation or exception in the amount of fee or compensation paid unless specified under paragraph 28. So again, this basically says commission has now been decided on. It is no longer negotiable because we've been putting it in here unless we specify something different in paragraph 28. Brokerage fee shall be earned, due, and payable when the agreement to purchase, option, exchange, lease, or trade is signed by the owner. Meaning that you've earned your commission technically when they sign an agreement. However, if owner shall fail or refuse to sell the described property for the price and terms set forth here, or if owner fails to refuse to complete the sale of such property within the agreement, buyer's full fee shall be due and payable to the owner. Basically what that is saying is, Mr. and Mrs. Seller, if you agree to do this, I get you a contract, you go under contract, you default, change your mind, whatever, you are still on the hook for my commission. Again, I'm just translating what this means, black and white. I'm not saying that's what you would do depending on the circumstances. It does say, though, that the broker in the second paragraph here, broker does agree to defer the commission until the closing date, which we all know how that works. Next paragraph talks about your protected date. It says here, if the property is sold within blank days of expiration or termination, people always ask, what should that be? That's totally up to you. I know a lot of people put 30 days. That should be the protection period to a buyer to whom the property was shown by the owner, broker, or another broker, or any person during that time. So basically, if it sells within that time after this, then you are still due your commission. However, last sentence, the protection period shall be terminated if owner enters into a listing agreement with another broker during that protection period. So basically, you're only protected if they're off the market, meaning unrepresented. If they do go into an agency relationship with another agent, or another broker, then that's null and void. And then continues at paragraph 2 on page 2, or section 2 on page 2 would say that for the purpose of the agreement, sale shall be defined as a transfer of legal, equitable, and beneficial interest in the subject property, whether for money or exchange of other property. but not limited to, any transfer of ownership, interest, or corporation, limited liability, partnership, or other entity. The reason that I do go into the detail in this is it does specifically say that the sale is defined when they transfer the title or interest for an exchange of either money or property. We have had a couple of times, again, just a little side note, we've had a couple of times in the last few months where funds had not transferred by the closing time of 5 p.m. That according to this definition, that according to the LLR's legal definition, that according to the paragraph in the purchase and sale agreement as it relates to final approval on financing, means that if you do not have those funds transferred at 5 p.m. on closing date, you do not have a closing and the contract is void. So just keep that in mind. I always feel like I'm just bringing y'all the most joyous news from the mountaintops. All right, paragraph 3, how we're going to compensate other brokerages. Basically, this one breaks down. You have 2 ways to compensate other brokerages, a flat amount or a percentage. Again, we don't have really a whole lot to talk about on this other than we do not compensate sub-agency. Kind of a moot point anyway, because there is no such thing as sub-agency in South Carolina anymore because of the transaction brokerage. However, we do compensate buyer agents as well as transaction brokerages, which are non-represented buyers. In my opinion, and I highly, highly recommend this be your opinion as well, the buyer agency compensation and the transaction broker compensation should be the same. Where it is specifically stated, both in real estate law as well as through the code of ethics, that an agent may not steer a buyer from a property based on commission, I still think it is a risk for you to not offer the same competitive cooperation fee to a transaction broker that you would to a buyer's agent. There's no need for that. Okay. I have had this question a lot lately as far as what the Keller Williams minimum is. There is not a minimum as it relates to in this. However, you do have to have approval if it's going to be below 2.5%. So if you are going to be offering out below 2.5%, you either need to get approval from your team leader or from me, just because when you start to do that, we're starting to offer out less than what we consider to be a full service fee. Not to say it's a definite no, we just want to get approval. In addition to that, if it's under 2.5%, the under 2.5 statistically, you can start to show that that's not the highest and best interest of your client. Okay. All right. Any questions so far? I'm going to take a quick break to read the 2 faces that I can see. Make sure I didn't lose anybody. See if there's any questions before I jump into the next part. All right. We'll jump back on. Section 4, earnest money. Earnest money is described the same in every document that we have. Earnest money is a promise that a buyer is going to give to perform on the contract. That being said, it is not a punitive contingency fee. It's not put in there to punish people. It's put in there to hold people to a promise. So if the buyer does default, as it says all in bold here, we still have to have permission or a court order for that earnest money to be released. And when I say we, I mean the escrow agent. So just make sure you understand, Mr. and Mrs. Seller, this is just a quick disclosure about earnest money. Yes, earnest money will be given. However, it is nothing more than a promise to perform on the contract. This is not a punitive contingency fee, meaning if the buyer walks, you don't automatically get it. Now, you could be entitled to it, but at the end of the day, we either have to have an agreement by everyone or a court order for you to get that. All right. Section 5, signs. Owner grants broker to put for sale sign, under contract sign, sales pending, or other signs on the property. And to remove other such signs, which I guess would mean that you'd be taking out signs that weren't either necessary, either someone else's, or you would remove for sale and put it under contract. Broker's duty. I'm going to read through this because, again, these are all things that can be used, or you can think of ways to explain this to be competitive. This is an extremely competitive market right now. Well, here, let me ask this question. This little pop quiz that you guys didn't know about. Is it easier or harder to get listings right now? You can either shout it out or type it in the chat box.
Harder.
It is harder. Why is it harder to get listings right now?
People aren't sure that they want to sell because they don't know where they'll go. They're
Okay,
afraid
so
they won't find
yes,
something.
so on case by case, that's definitely one right now that and that question was asked earlier about just to cross the bridge, is a lot of people are asking on a contingency for a seller to have to find the house that they want. We are speaking to our attorney about that. LLR or SCR has said that's an attorney thing. There is not an SCR form for it, and it's not on the table to have one. All right, so other than specific situations in this general market right now, why is it harder to get listings?
That was a good answer.
All right, I'll go multiple choice. Is it harder to get listings in this market now because it's a more competitive market, or there are not enough listings going on the market?
There are more agents competing for every listing that comes up.
100%. Okay, this is not an issue of number of listings on the market, right? They're the highest number of sales we've ever had in Charleston in 2020. And there's one common denominator on every sale that's happened in Charleston, and that is that there was a home to sell. Now, there were FSBOs, everything like that. So the listings are coming on the market. It's just a matter of being the competitive one to get your foot in the door before they do so. The reason I bring that up is you need to be thinking about everything you're doing in the process to stand out from your competitors. Number one thing is to be the first one in the door, right? I mean, that's it. I mean, statistically, it's 87% hire the first agent they interview. And honestly, we can debate, and a couple of very smart people in here, we could debate all day long on how ridiculous that is, that they wouldn't interview more than one person, but they don't. But when you do get your foot in the door, you want to make sure that you are incredibly competitive. So I always look for parts of the contract where you can stand out. By the way, being able to explain the contract, shockingly enough, will be a way to very much stand out as an agent. Now, not interpreted as an attorney, right? But to be able to explain it where they're comfortable with it. So going back into it, which section 6, the broker's duty, this what talks about what my services are going to be to you. I'm going to basically to secure a contract of sale on your property, directing efforts of broker's organization to bring out the sale, advertising the described property, different media that you're going to go through, everything you're in here. This can be your checklist of how you're going to do all of these, right? One thing that you should say in there is be able to help you translate, decipher, and sift through multiple offers. I think you do need to prepare your clients for multiple offer situation and how that can be tricky for them. So again, you just want to explain that's part of your duties on there. Paragraph 7, always the larger one because the attorneys got involved, is this is what we are not held responsible for. Right, the broker liability limitation. This is always the one that most agents don't want to spend a lot of time on, and quite frankly, I don't blame you, right? Because this is basically, hey, anything I do wrong, you can't hold against me. The easiest way, and I'm not trying to be smug about this paragraph, we honestly have a lot of consumers that are pushing back on this paragraph. Not a lot. We've had some that are pushing back on it that have said, why would I sign something that says you wouldn't be held liable for something that you did wrong if you did something wrong? And I get that argument. If that's something that you do have a customer or client that's pushing back on, let me know. The bottom line is there's not an attorney out there who won't look at this and say, it doesn't matter how much limited liability this form has on it. If someone's going to sue you, someone's going to sue you. Right. And that's not neither good nor bad. It just is the reality of it. However, it does say what it does allow you to do, again, from a strategic standpoint, is it does allow you to kind of work through the guidelines a little bit of what your actual job is as an agent in this, right? Sorry, I didn't mean to scroll down like that. It can go through and say all the things. It's not saying I'm not going to help you in all of these, but as it relates to things such as what it means for certain contingencies in a contract or these sorts of things, I'm going to guide you in the right direction, right? If inspectors are telling you that one thing needs to be done this, or the buyer's saying this and this needs to be done with that, I'm not an inspector. I'm not an attorney. I'm going to partner with all of these people. However, just know that these people need to come in. I'm only limited on how much I can do, which is really, to quite honestly, to secure the contract for you and then help you take that contract to close. Right. Then we jump into section 8, which are the owner's duties, which is what they agreed to do for you. Again, I don't think a good listing presentation will be to sit down and say, here's everything to do for me. However, this is a good opportunity to say, here's what this will look like, right? Any information that you provide for me is going to be reliable and accurate. Again, this is relating to a specific one. Are there any encumbrances or liens on the property that you know about? If so, you just need to disclose that in the property disclosure. Any inquiries that you get from anyone outside of directly me, immediately let me know so I can make sure I put them on our follow-up plan and make sure that we're qualifying and make sure we get everybody in the house that needs to be in the house. When we do have inspections, that you will let the property be inspected by the broker, the broker's agents that are in there, and the buyers, anybody they would send out there. Of course, we will know, Mr. and Mrs. Seller, it's not going to be an open door policy at your home. Part D, we're not allowed to discriminate. It's sad that they still have to have this in here, but they do, which is fine. Permit them to, this one's always an interesting one. This is not a service fee. A lot of times in E, people tend to use this as a service fee. It says to permit the broker to incur on behalf of the owner reasonable expenses for repairs, inspections, utilities, maintenance, and similar expenses not to exceed blank. This is not where you would do, I mean, I guess you could say our marketing fee would be in here, or a reimbursement for marketing fee would be in here. However, this is not where you would use like a one-time service fee or an additional fee that they pay you at closing if that is part of your practice. That would be done either in paragraph 28 or a separate document, which I know some teams use. Does allow, again, discloses here, this is that the closing attorney is the one who takes care of distributing the compensation. And then this does give them, this is an interesting one. And the reason I bring this up is we have a client right now who's just very, very unhappy that all the sold information and everything has been provided, and the information was published, right? I mean, the information can be published, it's public record. More and more of that is going to be shared through the MLS. I don't know what that looks like, but they can get it from the tax records and everything like that. So they just need to understand that this is where they're stating that that's going to happen. That can't be made completely secret. H is going to talk about photography, allow you to have the home photographed. I, conveying marketable title. This is an important one because marketable title means that it's free from any liens except those stipulated herein. Meaning if you don't disclose a forbearance that you've taken on your mortgage, or if you don't disclose that you still have payments on your, they make the lights come on, solar panels, right? If you don't disclose those, you're technically in breach because you've not disclosed ahead of time, and you've agreed to convey marketable title free from all of that. Okay, so you just want to make sure that you're asking those questions. Again, authorization of an attorney, not to deal directly with prospective buyers. By the way, I've seen a little bit this lately where it's been a little casual, where we've allowed our clients and the cooperating broker to communicate. That tends to be a little easier to do through DocuSign and stuff like that. Just even if it's a via email here and there, be careful on that. I mean, you don't have to be the security guard that's, you know, the keeper of all information and seem like a control freak, but a simple, hey, you know, here's the agent's emails in there, just send it to them. I've heard a couple of that lately. Let's try not to open that door. I don't feel like we have to keep a watertight vault. However, let's encourage the proper protocol for the communication to stay between the agents and brokers. And then lastly, if they do have any confidentiality thing, you know, if they want to be kept confidential, those sorts of things, then we have to have written instructions on what that looks like. All right, fun. Rest is all about disclosures. Paragraph 9, section 9. What this lengthy part here says, and the reason I don't go into this in too much detail is because I do believe that the property condition disclosure statement is an area that you do need to stay out of any sort of detail. And so what I always explain to the sellers on this is say, Mr. and Mrs. Seller, what this says is one of the documents you're going to fill out is what's called a property disclosure statement. Statement's going to basically ask you a blanket question of, with the following, any of the following situations in your home, are there any issues? You can either say yes, no, or I do not have any representation on there. It is your obligation to fill it out. It is not your obligation to go get an inspection and search for all the answers. So you either know yes or no. If you truly do not know, then you need to say that you truly do not know. All right. An example would be, if you truly don't know the type of piping in your house, then say that. Right. Again, that's an example, Mr. Seller. I'm just saying, if you want to make sure, because especially now, guys, this is super important, especially now when we're seeing a lot of buyers come in with repair procedure to be more competitive. And if the seller fills out something in there, accidentally says new HVAC unit, and they get in there and the HVAC unit's actually 10 years old, could be functioning totally fine, covered under repair procedure, but now you've got a little bit of a disclosure issue because they said new HVAC, right? Again, an obvious example, but an example nonetheless. Okay. So basically, Mr. Seller, what this is saying is that when you fill it out, you're going to fill out the best of your knowledge, and that once you fill it out, I'm going to disclose all that information, and that you cannot be dishonest or anything on there. It also states in here, should we get an inspection and something comes up that is on the seller's disclosure or on the property disclosure as an issue, you have to amend your property disclosure to update that. Now, I can feel it in your tones and see it in your eyes. Yes, that that statement means if you're a buyer's agent and you're under contract on a property and you find out they've got whatever major issue going on underneath the house, yes, what this states is that the seller needs to go in and update that property disclosure. And yes, there are ways to report that if it is not done. That being said, we're not, well, no, I shouldn't say that. I do believe there's an obligation to report. However, don't get super worked up on it. If your buyer is moving on to a different property, move on to a different property with them. Now, I'm not saying we don't do anything about it, but I'm just saying there are a lot of us lately who've had buyers go under contract, that contract's fallen through, and the agents, no offense, are much more wrapped up in the fact that the seller's disclosure hasn't been updated yet on that old listing versus what their current buyer should be doing. Okay. So don't think the world's out to get you. There, it does take time. And if it is something we need to send a reminder, we absolutely will. Just be careful that you're not trying to go down that road and losing focus of working with your buyer. All right. Paragraph 10 basically carries on from that and says that the owner authorizes you as the broker or the broker's agent to disclose information about the property to the broker's agents, prospective buyers, and all inquiring parties. Such disclosure shall be in accordance to the broker's company policy, which basically is to follow the full disclosure law. If it is a material fact to the property, it needs to be disclosed, right? And this is, by the way, if you are that listing agent and you get an inspection report and your buyer has some things that need, or excuse me, your seller has some things that need to be done to the house that would now need to be amended and changed on the property disclosure, it is their obligation to change it. If they refuse to do so, it does not mean you don't disclose it. Now, if that comes up, contact me, right? Because you're also now have a conflict because your seller doesn't want to disclose, but you need to disclose it. So you just need to be careful on that. Taxes, basically, Section 11 saying that the owner agrees to comply with the provisions of South Carolina Code, basically regarding withholding any required taxes of owners that are non-residents. So if you are dealing with second homes, vacation properties, just need to make sure they know that when they do, South Carolina has it set up that the closing attorney will ask for withholding, or could, I should say, should ask for withholdings at the closing. Coastal Tidelands and Wetlands Act, in the event the property is affected by the provisions of this, an addendum will be attached to the sales agreement. If you are the listing agent and this does apply, you want to make sure that, that would be disclosed as part of the insurance part of the disclosure, but you have that handy to counter should you get an offer on it. All right, everybody take a deep breath and stretch before we go to section 13. Hey, I don't think it's a coincidence that this is section 13. All right, so the elusive marketing date, coming soon, sharing information, blah, blah, blah. All right, I'm going to give you the Reader's Digest version of what the contract says, and then we're going to take some time to talk about some different scenarios that may happen. So they only can choose one as how this works for multiple listing service or public marketing. Option 1 is the property shall be entered in the multiple listing service of which the broker is a member, which would be whatever one you're choosing. Right now, the majority of the offices are a member of Charleston Trident. However, if you are a member of multiple of MLSs, Myrtle Beach, Beaufort, Columbia, just understand you now have 4 separate rules to abide by, and they are all different. They're fairly similar, but we'll talk through that. All right, so if they check option 1, it should be entered in multiple listing service for which you remember stipulated by their bylaws. This shall constitute an offer of cooperating brokerage to all member listing services. Owner agrees that the broker may compensate an agent representing the buyer from a fee described in paragraph 3. Owner agrees or does not agree that the listing will be placed in electronic marketing mediums, including but not limited to the internet, MLS, IDX data exchange, online computer services, shared listing data, everything that basically all of your listings go through. Owner further agrees to permit real estate firms who belong to any listing service of which the broker is a member to advertise the listing on the internet in accordance with the listing service rules and regulations. All bold means it's important. Broker and owner agree to abide by all rules and regulations of the multiple listing service in which the property is listed. That's option 1, which is the one that you're going to select 99% of the time. Then there's option 2. Option 2 says seller does not consent for the property to be placed in the multiple listing service and instead wishes to have their property listed as a brokerage exclusive. This will prohibit the seller and broker from conducting any public marketing, which includes but is not limited to site signage, social media, and other communications, oral, written, or electronic, that can be disseminated to the general public of the property and will restrict the marketing of the property to only members of the broker's firm. Broker and owner agree to complete any paperwork required by multiple listing service of which the broker is a member to verify the property will not be publicly marketed. All right, so let's talk through this. This is a fun one. Basically, option 1 goes in the MLS, option 2 doesn't go in the MLS. You're rarely going to have option 2. The only time you're seeing option 2, I don't want to go in the MLS because I'm a high net worth client and I've listed with a firm that I feel can find me a buyer without going public. Or I'm going to go in the MLS, which is what everyone does. So the MLS option, which is the first one they would initial, and then they would give permission to go on the internet. Let's go back to paragraph 1 that talks about the dates. This is why you can put the listing date as February 9th, even if your seller says, we want to go on the market March 1. You still would have the listing agreement signed as February 1 or February 9th. Okay. This does not require you to put it in the MLS within any time of the listing date on the contract. This is a big difference in how the rules used to be. The rules used to state it had to go in within 2 business days of the listing date. It does not say that anymore. The MLS has removed, and they did this in right away. The MLS did a very good job on this. We did a very, very poor job of telling people. MLS right away removed any sort of limitations that said you have to go into the MLS based on your listing date. They do, however, because it is an association-owned MLS, listing onto the MLS, it no longer asks for the listing date. It asks for the MLS entry date. That will be the date on which you are putting the actual MLS, the listing live into the MLS. That's not reflected anywhere in writing. Okay, that's not in the contract, in the listing agreement or anything like that. Now, here's the challenge. The moment you go public with your listing in any of those ways that they described before, you then trigger the clear cooperation policy, which states within 1 business day, which is by 5 p.m. the following business day, you have to have your listing go into the MLS. Okay, so go back to the same example. Today's February 9th. We list it. I'm going to put it on March 1st, but I'm going to decide to tell people about it ahead of time. If you tell anyone outside of KW, and we have verified, and we've gotten that verification today, and just so people are asking, we are going to start, we're have a couple people working on either a Facebook or a Google Doc. We'll probably do both, where it's simply for coming soon listings for Keller Williams agents locally, because it is under the same broker's firm. So if Karen lists it under the broker's firm, me as the broker in charge, that's the beauty of LLR. LLR puts a lot of weight in the broker in charge. And just because Keller Williams doesn't matter. It works for our advantage from an exposure standpoint. And so if it's listed under Mount Pleasant, then we can also, because technically if you don't allow that, then even Isle of Palms and Mount Pleasant couldn't share, right? So if they had separate brokerages, but similar ownership. So we are going to have it set up where we can do a citywide share on that. Does not include members of the MLS from Keller Williams and Columbia or Myrtle Beach, just the offices in which I'm the broker in charge. Okay, so let's come back around to that. So you can share it with everyone within here. Now here's the challenge though. If I share it and Karen has a buyer that's interested, she needs to make sure that buyer is very interested in it before she tells the buyer, because if she gets very specific on the buyer, that's technically going public with it. So you've just got to keep that in mind. This isn't a free-for-all to go do showing. The purpose of it is not necessarily to do double-ended sales. Don't get me wrong, that would be great. But we also need to keep in mind at the end of the day, it's hard to argue to a listing or to a seller as a fiduciary agent to them that it's not in their highest and best interest for the most amount of potential buyers to see their home. It's just, that's hard to argue. Now, you'll have situations that, hey, if a qualified buyer comes in, I put coming soon on something, Karen says, hey, I got somebody who's chomping at the bit, and they throw in an offer contingent on them seeing the house, due diligence, and they put it together. There's nothing to be said that seller doesn't say, no showings, no cleanings, nothing like that, sign, right? You can't stop the clients from doing it. Just need to make sure you advise the clients of what's in their best interest. Okay. Now, here's the other thing. Well, what if I want to create some urgency? Okay, that's fine. You can put your house into the MLS and then restrict showings. They've also removed, actually, they never really had it. They removed any stipulation on how long it can be in the MLS without showings. So let's say you listed it today and they've got over the weekend, they're doing some things, that sort of thing, but you want to create some urgency, you can throw it in the MLS and then just restrict showings. Caution, it goes on to the world as a full listing. So it's still going to be the first impression that online buyers see. So a lot of people say, well, that's great. I'll just throw a front picture of the house and throw it on there. I don't think that's a great idea because you want to create the stickiness from the very beginning, but you can put it in there and restrict showings for a certain period of time. That's how you can get quote unquote around it should someone go public with your listing and you get reported. All comes down to reporting. And here's the deal. I'm all for self-policing. I actually am very for self-policing. I think we need a lot more of it. I will be honest with you, and I know this is being recorded. I don't think this is one of the areas that we need self-police for the most part. I do think there are some people who are abusing coming soon. I get that. If I get a blast email from an agent that goes out to all of the agents in the MLS that says I've got a listing coming soon, that to me, I don't feel the need to go report that. I don't think that's the problems we have right now. That all being said, we want to stay above board, which is why we're working on internal things and that such. Questions? I typically always get the question right now, is the MLS going to be considering putting a coming soon module? As someone who has literally been screaming from the mountaintops for 5 years at MLS to have a coming soon module, I no longer think it's really necessary based on the fact of we can put it in there and restrict showing, right? I mean, and quite honestly, in this market, you're holding a listing over a weekend is hard to say is in the best interest of the seller if you're simply trying to create urgency to get buyer leads. And that's the thing we got to be careful on. You want to be careful on things of, well, I need a chance to get buyer leads. That's great. However, your fiduciary responsibilities to the listing. The other thing that I'm hearing, and I just, I get it, I just appreciate if you don't say it out loud, is, well, it messes up my days on the market. If I put it on and it, I've got 5 days, I'll go a week before it goes under contract. I get that. I totally understand that. If that short a period of time is really probably not going to make that big of a difference. It isn't a perfect rule.
Sometimes if it goes under contract too quickly, then your seller's convinced that you underpriced it.
Yeah. I mean, that's the thing. And I so appreciate you saying that, because I always love when people are like, well, no, I mean, you just tell them obviously it went under contract quickly because it was priced perfectly. That's nice in our little real estate bubble. That's not, even in this market, consumers, they hear multiple offers, right? I mean, they hear all of that. If it goes under contract right away, they're still questioning that. So Karen's absolutely right on that. All right. Let's jump back into this listing agreement. Jump into the next one, lockbox. This is where you would put that the owner agrees, does not agree to have the lockbox on the property. You do not need a separate lockbox addendum unless the property is tenant occupied. Then you will want to have the tenant to sign that. By the way, you are not the property manager if you do list of tenant occupied property. It is not your call as to whether or not how the notice you need to give on showings. It is not your call as to what the law states or anything like that. You need to make sure that the property owner is dealing directly with their tenants as it relates to stuff like that. I absolutely think that you should build a great relationship with the tenants. However, you have to be super, super careful from a legal standpoint that you're not translating a lease term incorrectly to a tenant that you don't represent. Okay, so you just want to be very careful on that. Other offers, it says here the owner understands the buyer's responsibility to present for owner's consideration terminates at the closing of the subject property or expiration of the agreement, whichever occurs first. So if I get offers on your property after closing or the expiration, I don't have to give it to you. Marketing the property after accepted offers, the broker shall not continue marketing the property after an offer has been accepted unless otherwise requested by the owner to do so. This is worded very weird because the thing is obviously the seller wants you to still market it. However, we do have a rule that states that it does have to be marked for active contingent, but it is still being marked. There is some discussion on making that active contingent to have another option that has contingent on a home sale specifically. And let me be very clear on this, that active contingent is non-optional if it is under contract in any situation. A seller can't put something in a contract that states that we're going to leave it as active. The MLS rules and regulations apply to you as the agent, not the seller. Section 17 says basically commissions are negotiable. Section 18 is fairly important. Agree to maintain the property, include the lawn, shrubbery, grounds until the day of closing or possession, whatever comes first. Owner also warrants that all heating, air conditioning, electrical, plumbing, water, built-in equipment or appliances shall be in operative condition on the day of closing or possession, whichever occurs first. Now, again, this doesn't supersede the contract. However, it does state in here, if none of this is not working, then we need to disclose that so we're not obligated to do so. Agreement to sell means if you sign an agreement to sell, you'll agree to sell it. Lead-based paint, if you do have a home built before 1978, you will be required to fill out the disclosure on this and provide it, and we will also be required to disclose that to the buyers. Mediation clause says if we do get in an argument that you and I will agree to mediate before we'll start suing each other. Really, Mr. Seller, the only way there'd be a mediation clause or a dispute is if we went to closing and for whatever reason you just refuse to pay my commission. Fair housing, just again to state that we do not discriminate. We are going to be having this property opened up to anyone, regardless of race, color, religion, sex, handicap, familial status, national origin. Actually, this needs to be updated. It does also include sexual orientation and gender identity. So just make sure that you do disclose that to them. We can use fax machines. It's good that they still have that. You can use faxes in here, but they haven't updated fair housing. Enforcement basically says the parties agree the broker may take action to enforce the agreement to collect their costs. Again, I don't know that I'm spending a whole lot of time on this one. Paragraph 25, if they do have, it is not my responsibility as your agent to disclose or find out information on criminal or sex offender information. They need to find that out on their own, as do the buyers. Last page, paragraph 26. Seller irrevocably conveys any and all seller's audio, photography, video rights in perpetuity involving seller and seller's family, seller's property to broker for marketing and advertising. This sentence is way scarier than it needs to be, but it does need to be said. And this goes back to the part that I said earlier. The issue is not so much the information of the sale, it's the fact that they still had pictures of their home out on the internet. And you just need to disclose to your sellers that this does stay out there. There's zero probability, even if we turn the MLS off, there's zero probability that those photographs would all be taken down. Paragraph 27 does say if you do want to surveil your property while it's being shown, you're welcome to do so. However, you do have to abide by any laws and regulations regulating audio and video surveillance. And that whether or not they agree to let me disclose or let you to disclose that it's being surveilled. I don't have the answer because I don't want the answer. If they ask what those laws are, have them go look those up. Because the surveillance laws are tricky at best. And there's a difference between audio and video surveillance and everything there. So if you've got someone that's really, really stuck on this one and they're demanding an opinion from you, it's not happened yet, just let me know.
Joseph, can you give feedback? That works well if you've got somebody that's got cameras and stuff, but A lot of people don't have them. And so they go, well, what do we do here? Seller agrees that broker may or may not disclose potential surveillance. You don't have it. You know, it's not,
Right,
it's
so
an NA.
It's an NA, which is a good point. You know, Mr. and Ms. Seller, here, there's two different ways we can do this. We can put that I can't disclose it. Just know if I do that though, and you do start to surveil, then obviously that's not something I will disclose to them. I'm not obligated to. It's completely up to you, right? However, if you do in here that I can disclose it, and you do decide to change your mind and put audio list, you know, whatever it may be, then I just would be able to disclose it at that point. But I would say for this, if you have one who doesn't have either one of them, you can either strike through them and initial them. You could leave it blank. It doesn't make it voidable, or you could just say not disclose, and then you don't have to worry about it, because then if they go change it, they've already told you you're not going to disclose it. And by the way, it's not a terrible thing to do. We had Lynn's aunt in Charlotte listed her house, and they couldn't get any feedback. So she put a recording device in her kitchen and took notes and made all the changes from the buyers that talked about it, and sold the house after they did it. Now, understand, in the buyer's agency agreement, it is disclosed that they may be surveilled. So it's really no longer a tactic. And if you are, by the way, just keep this in mind. If you're at the home, putting the lockbox on and previewing it before it goes on the market with your agent friend, it may be surveilled. If you're with a buyer looking at a home, it may be surveilled. So just be careful on all of that. And then the rest of the agreement are signatures, and everything's good to go. Questions?
Hey, Joseph, I have a quick question for you. Is there a time frame? I know you mentioned before about the time you listed before the time you can show it. Is there a time frame? I know in New York they give you no more than 2 days to show the property if you hold that restriction, the showings.
As far as the MLS is concerned?
Yeah.
No, there's not currently a time frame in there. No, I wouldn't be irrational. Because there's also like regulations, and then you don't want to annoy people. Right. Not that you want the tail to wag the dog. You know, if it's going to be, I would say anything more than 2 weeks, you're probably starting to toe a little extreme. But they've taken out any specific time frame.
Okay, thank you.
Yep. Anybody else? All right. Well, as always, of course, if you have any questions, email me, joseph@kw.com. We will get this posted to YouTube so you can watch it again, as well as all the other ones. And then next week, we will be going through the purchase and sale, which is always a good one, because I'm telling you, we're seeing crazy things right now. Everybody's like, I've heard the purchase and sale. I'm sure you have, but I can promise you there'll be a story told that came up within the last week that you haven't heard, and you need to hear them, right? And even if I know we have a small group of people on here. Even if you're new, you haven't written yet, I'm telling you, I would say come to all of these. One of the things that I did probably for the first 3 years, 5 years, I still went to them even before I became a broker again. Come to contracts class. I mean, Karen's a perfect example. Not to call her out, she's in here when she's already enough. You know, Karen's one of the more knowledgeable people that I would say as it relates to the contract. She's in here taking diligent notes, asking questions, do all these. It is ever changing. And I do believe where you're not a lawyer and you shouldn't be interpreting a contract, the more comfortable you are understanding these contracts, the more comfortable your client is in trusting you. I always use contracts in my presentation because they made me sound much, much smarter than I am. And contracts can do that. So, all right. If you have any questions, let me know. Otherwise, I will see you guys around. Happy selling. Go write lots of contracts.
Thanks.
Bye, guys.
Bye.
Thanks, Joseph.
Uh-huh.